we've got Jim Hewitt here with us. He is the author of the recently published book In Cold Storage, which you all got a copy of. And I hear it's excellent. I've started it, and it's really good. So with that, we will let Jim get to it.
Thank you very much, Sarah. And good afternoon. It's nice to see you, especially to see two of my former law clerks, both of whom went on to the Supreme Court. You guys know a whole lot more about the Supreme Court than I do, so I hope you will not be too critical about what I have to say. But I would like to tell you a little bit about my book and why I wrote it and what it's about. And I have to tell you something about the book so that you can understand the legal issues that are involved. Harold Nokes is an interesting man. He is in the penitentiary out on South 14th Street. He's been there since 1974, and he's going to be there until he dies. He's about 86 years old. He's an interesting man. He was part of one of the most bizarre murders, or double murders, that ever happened in the state of Nebraska. And I'll tell you a little bit about it. But Harold is old and stooped now. His hair is gray. He's missing 3 teeth. He's got a bad shoulder. But when he was in his prime, in his 40s, Harold was quite a stud, actually. And it was the fact that he was a stud that got him into the difficulty that he found himself in. And that's why he's been in the penitentiary since 1974. But Harold worked as a foreman for the highway department in McCook. Actually, he was in charge of maintenance of highways and bridge abutments and things of that sort. And he had in his crew a young man named Dwayne Hine. Dwayne Hine was married to a young woman named Kay White. And Dwayne and Hine had been married since they graduated from high school, and their marriage was pretty much on the rocks. They weren't getting along very well. And Harold and Kay Hine became good friends, very good friends, as a matter of fact. Kay asked Harold one night to meet her because she had some very serious questions that she wanted to talk about. And he said yes, he would. And so he met her in his car, and they drove to a country road outside McCook and commenced about a year and a half tumultuous affair. It happened with, and this is why I tell you Harold was a stud. This happened with frequency 2 or 3 times a week. And for somebody in his 40s, I thought that was really pretty good. In any event, Harold and Kay went along for some time. Kay thinking all along that Harold was going to divorce his wife and marry her. I don't know whether he ever really told her that or not, but at least he conveyed that impression, and she certainly bought into it. Well, Harold not only managed to convince her that it would be a good deal to continue their affair, but he said it would be a good deal if we brought my wife into it and we had a menage a trois, a sexual threesome. And believe it or not, Kay said, okay, I'm willing to do that. And so they did, and they embarked upon a sexual threesome. And all the wonderful graphic details are in the book, so you'll want to pay close attention to it. But it went on for about a year, a little longer than that. And Kay finally figured out she was not America's swiftest mind. She finally figured out Harold was not going to divorce his wife. He was not going to marry her. And so she pulled out of menage. Then Harold decided he had to get her back. He was enjoying what was going on. He thought it was be a good idea to get her back. Ina, his wife, liked her very much. And so they tried all sorts of stratagems to get her back in. None of them worked. Kay decided she would show Harold that she was still very attractive and of marriageable quantity, and she began, I'm not sure precisely how I would put this in mixed company, but she began spreading her favors around McCook very, very gracefully. And about 7 citizens of McCook took advantage of her. And Harold really got upset about that. And he, first of all, he poured sugar in the gas tank of her car, a very nice deal. He took, because he was the highway foreman, he took grass or weed killer out to her house, put it all over her front yard, burned up her entire yard and most of the trees in her yard. And just in general made a terrible nuisance of himself. Nothing that would be the sort of activity that would bring somebody back into a sexual relationship. And she must have thought he was one of the biggest jerks she ever met, but in any event, Harold then decided he was going to publicize her activities, and so he began to write on bridge abutments and on highway structures all across the McCook area that Kay Hine was a very promiscuous woman, and he spelled it out in the old classic four-letter word, and he said, if you want a good time, call her at this number. The fact was, he listed the names of some of the people in McCook who were engaged in her activities, and they got upset about it. And so they complained to the state patrol and to the McCook Sheriff's Office, or the Red Willow Sheriff's Office. And the state highway patrol and the sheriff's office interviewed all kinds of people and tried to find out what was going on. They never did interview Harold Nokes. And I tell you why in the book. But in any event, they made a very significant report about what had taken place, and the highway patrol have that in their files. Harold ultimately, and we don't know why, Harold ultimately lured Kay Hine's parents to his home on the 23rd of September of 1973, and apparently shot and killed them both. We know that they were both shot. We don't know how many times he shot them, what the circumstances were, other than what he has told us. And I don't think what he has told us is really worthy of much belief. But in any event, that took place. Harold had a bad shoulder, and he had gotten it falling off his front porch while he was chasing Kay. And he decided he could not carry the bodies up out of his basement and dispose of them in a canyon somewhere around McCook. So he took an axe that he had in his pickup and a butcher knife, and he said he took an axe. His right arm was really in bad shape. He said he took the axe with his left hand. He gripped the axe about halfway up the hand and decapitated both of the bodies, severed all of their limbs, cut their torsos up. After the bodies were dismembered, he and his wife, Ina, wrapped them in freezer paper, put them in their freezer until they were frozen, and then took them out to Harry Strunk Lake near Cambridge, which is about 25 miles from McCook, and threw them in the lake. Well, as things tend to happen when you throw body parts into water, they start to decompose, the gases are released, and they start bubbling up to the surface. And the body parts did, in fact, bubble up to the surface on the 3rd of October. And that was what really started things going. But prior to that time, the White family had hired Bob Sawden, who was a private detective here in Lincoln, formerly the head of the Lincoln Criminal Justice Department, and a very capable police officer. They hired Bob Sawden as a private detective, and he was in McCook trying to find out what had happened to the Hoyts and where they had gone when the body parts began to surface. He had access, because he was very prominent in police circles, he had access to the Highway Department's report of the sign paintings. And so he called Harold Nokes into the Highway Patrol office in McCook on the evening of October 2nd and quizzed him at twice a night. And that's one of the first issues that I want to talk about in just a minute. He talked to him at some length, asked him if he would take a lie detector test. Nokes said he wouldn't take a lie detector test, but he got Nokes to admit that he had had an affair with Kay Hine. Didn't say anything about the menage of the three-party relationship, but Nokes at least admitted that he had an affair with Kay Hine and that he had told his wife about it. Well, when the body parts began to come up, the first few parts were hands and arms, and on the hands of the female who was involved, who was Mrs. White, were rings. They had not removed her rings when they chopped her up. So she had a wedding ring on one hand and a birth ring on another hand that showed the 5 children she had born and what the dates of their birth. The other daughter who lived in the McCook area, Donna Elmer, identified the rings as her mother's, and so they knew what had happened to the Wicks. McCook went into a panic. They thought there was a monster loose in the community. It was really very, very difficult in McCook for a long period of time. These parts surfaced on the 3rd of October. No kid in McCook got to go trick-or-treating on Halloween that year. Parents were absolutely petrified about what was going on. It was really an interesting situation. Well, in any event, Bob Sawton, because he was a good interrogator, finally decided that Kay Hine was not telling the truth when she and all the other members of the family had talked about what might have happened to her parents, what he was investigating. So on the 11th of October, Sawton went to see Kay Hine and got her to admit. And it is a fascinating, maybe a little bit more, got her to admit the menage. And Paul Douglas gave me all of his files, and it is in there. I would be happy to make a copy if anybody really wants to read something scurrilous. I'd be glad to let you read it. But in any event, she told everything, and that's what really got things started as far as Nokes were concerned. She said, Nokes has done all this stuff to me. He's hurt me. He hit me. He's broken off our relationship. I think he may have had something to do with it. Now that's all there was. There was no other evidence as far as Harold Nokes was concerned. The next day, Floyd Clark, who many of you probably know, who was the county judge of McCook, issued a search warrant to search Nokes' home. There is a question in my mind, and we'll talk about that in a minute, as to whether there was probable cause for issuing the search warrant. They didn't find anything in the search warrant, but it was a point that was raised in the appeal that ultimately got to the Supreme Court, even though Nokes pleaded guilty. Judge McCown disposed of it very quickly. Scott, you have been the guy who wrote the opinion. He said, a guilty plea wipes out everything, and that's all there was to it. But in any event, there was that issue as far as what happened on the search warrant. They couldn't find anything on Harold Nokes. They tried, they looked at everything. They thought he was guilty of sin, but they couldn't find any evidence. So finally, Fred Schroeder, who was the county attorney of Frontier County, the body parts were found in Frontier County, and so he was acting as the county attorney until they realized, ultimately when Nokes confessed, that the killing had taken place in Red Willow County. But Fred Schroeder went into district court before Judge Jack Hendricks and tried to get a wiretap order to put it in the Nokes house. That was really a very interesting issue. I'd like to read to you just a little bit so you understand precisely what happened. Judge Hendricks is sitting there listening to Fred Schroeder ask for the bug, and he said, now this is one thing that rather intrigues me, Mr. Schroeder, and you will excuse me for interrupting you. But the law under which this is brought requires the court to determine prior to the giving of the consent to what you were asking for, a determination of probable cause. And that's true. The statute then and now says that you have to have probable cause that somebody has done something before you can get a wiretap. He said, now, can you give me your thoughts about this court finding probable cause, and yet you have reservations, certainly, perhaps even more than that, about filing a charge at this time. You follow me? You are asking me to find probable cause when you feel that at this juncture you do not have sufficient evidence to file a prosecution case. I think that raises a very serious question about whether or not they had the authority to put the bug in the Nokes house. And if they put the bug in the Nokes house, did everything that they learned from the bug become the fruit of a poison tree? The only thing that they really learned, at one time, Jack Sexton, who was a wonderful highway patrolman from North Platte, said, I listened to it for hours and hours and hours after they finally granted the permission to do the bug. And he said, all I ever heard him say was how much they disliked me. But in any event, they tried to set up the bug. They picked the lock. They had a highway patrolman try and pick the lock. He couldn't do it. They brought somebody out from Lincoln who picked the lock, and they installed the bug. And whoever installed the bug did a very poor job of installing it. And the Nokes were heard to say, something's wrong with our TV. It was working this morning. We don't know what's the matter. Let's call our TV repairman and get it fixed. The sheriff, who was listening, called the TV repairman and said, my God, there's a bug in the house. Don't screw it up. So in any event, that's what happened. But the only thing that they ever really heard was somebody, and they think it was Nokes, they couldn't remember, said, we should have removed the rings. That was the only comment. Nobody ever said, yeah, we killed them, or we shouldn't have killed them, or we did this, or did that. The only comment was, we should have removed the rings. But they also learned that the Nokes were so upset about this that they said, if we are arrested, if they arrest us and are going to prosecute us, we're going to commit suicide. And so they decided that they would use pills to do some stuff like OxyContin. That's not right, but I can't think of a name right now. They had these pills on them when they were arrested. Finally, Harold had 53 pills sewn into the waistband of his pants. Ina had 81 pills between her brassiere and her purse, and they were confiscated. Harold was put in jail in Curtis. Ina was put in jail in North Platte because Curtis didn't have any facilities for a woman in their jail. So Harold didn't know that Ina had lost her pills. He only knew he'd lost his. Ina didn't know Harold had lost his. She only knew she'd lost hers. The key was if we were going to trigger this, Ina was to get word to Harold that her back hurt. That was going to be the key for them to commit suicide. Dick Hogue, who was their lawyer, did a very good job. Dick had gone to North Platte to see Ina, who was in jail in North Platte. Came to Curtis to see Harold, and then went to Colorado on a ski trip. Lanny Robley, who was the sheriff in Frontier County, was a very bright, very capable guy. Lanny went to see Harold Nokes, who was there in prison, in jail, and said, Dick Hogue told me that he'd forgotten to tell you something when he was here, and he wanted me to pass it along to you, and that is, Ina says she's having a lot of back. Well, Harold didn't know that Ina didn't have her pills. We don't know whether he thought that she was going to commit suicide, but he didn't have any pills, so he could commit suicide. So later that evening, after he had previously tried to cut his wrist by pulling a lens out of his glasses, Harold called Lanny Robley in and confessed, told him what had happened. A few days later, Paul Douglas, who was the special prosecutor of the case, took a court reporter from Lincoln to Curtis, and they took a 158-page confession from him. And it was a very, very interesting confession. Lanny Robley had said one thing about, or had heard one thing about the disposal of the heads, for example. Nokes in the confession said something different, and Robley was there both times, so he didn't raise the issue. But the question becomes, if Nokes did not confess, if he did not confess, did Lanny Rodley trick him into giving a confession? So there are a number of really interesting issues in the case, and I think that's enough of a précis about what actually happened until you get to the question of the sentence. In 1972, the Supreme Court of the United States threw out the death penalty in case Craig Ginsburg. So in 1973, following the lead of the state of Georgia, we adopted our statute, which has aggravating and mitigating circumstances as far as determining whether somebody is going to get the death penalty or not. Right now, I've been in Colorado for a while, so I haven't seen for sure whether or not they got enough signatures to stall the repeal until they vote on it next year. But at least we're going to vote on it in 2016. So all of the stuff that I'm talking to you about, aggravating and mitigating circumstances, have been repealed in the last legislation. But I strongly suspect that we will see them come back at some time along the line. Anyhow, we had a three-judge panel, first three-judge panel we'd ever had since in 1973, our legislature had just adopted these standards. So Paul White, who was the Chief Justice, appointed Herb Ronan from Lincoln and Bill Caldwell from Pawnee City to sit with Jack Hendricks, who was the trial judge and who was the judge in both Frontier County and Red Willow County. They had charged Nokes with one count of first-degree murder, the murder of Mrs. White, based on what he had said in his confession, and one count of second-degree murder, the murder of Mr. White, which took place first. Nokes said that White threatened to hit him, he shot him. White didn't know that Nokes had a gun, and the whole story about Nokes pulling the gun and firing the shot is just so much baloney in my opinion. But in any event, he did have time to form an intent on shooting Mrs. White, who was there. And so the three-judge panel determined that they had to decide what was going to happen on the first-degree murder charge. They found him guilty of life, found him guilty, but sentenced him to life. They found that there were two aggravating circumstances. He committed the murder to conceal a crime, and he committed another murder at the same time. And they found that there were two mitigating circumstances. And the interesting thing about it is there is not one iota of evidence anywhere in the mitigating situation, and the burden is on the defendant to prove mitigating circumstances. There was nothing in that particular hearing to show that Nokes was under great mental stress, under the influence of great excitement. But the court, that didn't faze Judge Hendricks. Judge Caldwell was the only judge still alive when I was writing this book. And he told me that Hendricks did not believe the death penalty and did not want to impose the death penalty. Hendricks' daughter, whom I interviewed, said the same thing. He didn't believe the death penalty. And Hendricks said, we don't want to give Nokes the death penalty. So they tried to figure out how they were going to come up with it as far as the mitigating circumstances were concerned. And they said, I thought this was interesting. The defendant had just killed the husband of the victim after a confrontation in two homes in an automobile. At this point, any normal person would have to be under the influence of extreme mental or emotional disturbance. This defendant, with his particular personality, the sexual and emotional involvement he had entered into with the daughter of the victim, and his immature reaction to his rejection as a lover, makes it obvious that his mental and emotional disturbance was of the greatest extremity. I thought that was very interesting for the court to say that. You know, there was a time in my life at 20 when I was 20, I would have thought being denied sexual intercourse was really something that led to great emotional disturbance. when I was 45, as Harold was, it was kind of, yes, maybe. At 82, I can guarantee it's a relief. But in any case, I thought it was very interesting for the court to have come up with this particular aspect. So those are some of the issues that I'd like to talk to you about as far as the legal issues are concerned. Ina Nokes was tried, actually pleaded no contender, even the judge found her guilty. But she was not charged with being an accessory after the fact. She was not charged with being an abettor. She was not charged with anything other than wrongful disposal of a dead body. She pleaded guilty to, or not no contender, and was found guilty on 2 counts. She was sentenced to 3 years on one and 2 on the other. She served about a year, 2 years, and was put on probation and never spent another day in jail. Ina is still here in Lincoln. She lives out north of the East Campus in a housing development that is designed for people who are low-income type people. I went out to see her and asked her if she would comment about the book. And she said, I took former Judge Sam Van Pelt with me. I thought I needed a witness, so we went out to see her. I knocked on the door, and she came to the door, and she said, I'm Jim Hugh, and she said, I know who you are. And I said, I'd like to talk to you about it. And she said, I'm not interested. Slammed the door, and that was the extent of that. I have talked to Harold, and I'll tell you a little bit about that later. But in any case, Harold negotiated. He'd already confessed. He'd given Lenny Rumley this complete confession, but he negotiated, and I talked to Douglas and said, why did you do this? He negotiated this easy treatment for Ina Nokes before he would do anything more. I think they could have just said, we're going to try you anyhow, and we're going to charge Ina with being an abettor. Douglas said, I didn't have any proof that she killed either one of them, and he said, I didn't want to put Red Willow County, by then they figured out it was Red Willow County. I didn't want to put Red Willow County to the expense of a trial in that regard. So Ina got off pretty much scot-free. Harold was nailed in an interesting situation. They told him, you'll be okay because the Board of Pardons, after about 20 years, he was sentenced to 2 consecutive life sentences. The Board of Pardons will commute your sentence to a period of years, and then you'll be able to get out without any difficulty. Well, that was fine until Kayor became the governor, and the Board of Pardons at that time said, we're not going to commute life sentences anymore to term years, and that was pretty much it as far as Harold was concerned. He was done, and he's there, and he's still there, and he will be there. But anyhow, I'd like to talk to you a little bit about some of these legal issues. If this case had not wound up in the status that it did, would these have been viable legal issues? I'm not a criminal lawyer, never have been. But I thought it was very interesting to think about some of these issues. The first issue I want to talk about is when Bob Sawden called Harold Nokes to the State Highway Patrol office on the 2nd of October. No bodies had been found at that time. Nothing had been found. Nobody knew that the Whites were dead. They were just missing as far as the family was concerned. So here's Sawden as a private detective, a former patrol police officer, well known throughout the state of Nebraska, who's questioning Nokes at the State Highway Patrol office. Now the law, I think, is that you don't have to worry about Mirandizing somebody if they're not actually in custody. Until they go into custody, you don't have to give them the Miranda. But what is there the appearance of custody? Nokes doesn't know anything about it. He's here at Highway Patrol office. He doesn't know who Sawden is, other than Sawden's a former policeman and now a private detective. And he's asking him all these questions. getting him to admit the affair. Sawden already knew what people had said in the State Patrol Office report that had come out that summer. So, is there a question? Is there a question there? Should Sawden have said anything to Nokes about, you might be a suspect in this situation, we're concerned about it, here you are, will you take a lie detector test? It's not clear as to whether he said you can leave at any time, you can get up, Nokes stay and talk to him for some time. I at least raised the question as to whether or not there was any responsibility as far as Mirandizing. But our law seems to be in the same principle that you don't need to Mirandize somebody unless they are actually in custody and they know they cannot leave. I think that's probably the situation. But I thought at least it was an interesting situation to raise. Another situation that troubles me, it doesn't trouble me very much because the way the case worked out, but the issuance of the search warrant on the 12th of October, the day after Kay Hine had spilled her beans about what had happened as far as the menage was concerned. They issued a search warrant to go to the Nokes house and see what they could find. And they looked for blood on the floor. Nobody had confessed. Nobody had said anything at this time. This was all speculation. They searched for blood. They looked for blood on the floor. They jackhammered around the floor drain to see if they could find anything. They found a nightgown that was stained with menstrual blood, but they couldn't find anything that in any way indicated that Harold Nokes had, or Enid Nokes had done anything as far as committing a crime other than, if you want to say, a sexual menage, and if you want to push adultery to the wall. That was the only crime anybody knew anything about. Now, is that a problem? Again, this was raised by Jim Kelly, who took the appeal to the Supreme Court. Had gotten out of the case by then. But Jim Kelly took it to the Supreme Court, and that's when Judge Hill McCown said a guilty plea wipes out any kind of problem of that kind, so we're not going to look at it. Well, it seems to me that it was not, they were not justified in issuing a search warrant. Let me tell you what the statute says, just so you've got it. No warrant shall be issued to search any place or seize anything in the possession, custody, or control of any person engaged in procuring, gathering, writing, editing, or disseminating news or other information for distribution to the public through a medium of communication, unless probable cause is shown that such person has committed or is committing a criminal offense. Now, search warrants have been said by our Supreme Court, it's okay, you can issue them on hearsay, for example. But doesn't there have to be something that says Harold Nokes committed a crime other than having a lot of sexual activity? They're not looking for evidence of adulterous crimes. They're looking for evidence of killing people. So why? Why? I don't know. But I think it was an interesting situation of that kind of. Boyd Clark is a good guy and a good judge. He had only been the judge for a few months at the time this took place. And I think he may have been bamboozled into issuing a search warrant. But in any case, that's the situation. One of the things that I think was really, really very interesting in this case was that for the first time, somebody in Nebraska said under our statute that killing somebody in the normal circumstances is what we're really concerned about. We're not concerned about what happens after somebody is shot or stabbed or something like that. Remember the Hunt case? The case in Norfolk where this Hunt went to the trailer of the young woman he found her picture and her address in her engagement story in the Norfolk Daily News. He went to her trailer, strangled her, stuffed her panties down her throat, put her in the bathtub, pushed her under while she was still alive, pushed her under, and then masturbated on her stomach while she was dead. And the Supreme Court, there are those of you who will remember this. This was during the Kravoshik years. The Supreme Court said, that's not heinous, that doesn't fall under paragraph D of the aggravating circumstances. So the fact that it was a terrible, terrible situation does not constitute heinous, and it's not an aggravating circumstance. Judge Caporale wrote the opinion. I criticized him very strongly in my book, which is a history of the Nebraska Supreme Court. Judge Caporale was in law school with me. He's a brilliant guy and a very nice guy, although he has not been as friendly to me since the criticism as he was before the time that I criticized him. But in any case, that's the story, isn't it? The Hunt case, isn't that the law now? It doesn't make any difference. The fact that Harold Nokes dismembered these bodies, chopped them up into little bits, that doesn't make any difference. He shot him. He said he shot him, and so that's all that counts. And the court, the three-judge court, in this particular case, said that's what the situation is. It says, let's see, precisely. Well, I'm not catching it right now, but that's what the court says. But subsequent to the Hunt case, and you remember Mike Royko of the Chicago Tribune got in a big fight with Norman Promotion. They argued back and forth for quite a while. Norman said he wished he'd never gotten involved in that with Royko. I think it was a good idea. But in any case, there was a case that happened here in Lincoln involving one of the absolutely sleaziest people ever to come down the pike in Nebraska, a guy named Wesley Perry. Wesley Perry was one of the most terrible human beings anybody could have ever involved in. I mean, just awful. Wesley Perry went out into Havelock. He was working on the maintenance crew at Nebraska Wesley. And he went out to the Minster coin shop in Havelock. Went inside, and Mrs. Minster was the only person in this store. And he shot her and stole a lot of coins. They caught him, they caught him putting some of these coins from the Minster coin shop into the what do you call it, vending machines in Nebraska Wesley. That's how they caught him, figured him out. You know, he wasn't a real brilliant guy, but he was a really bad guy. But in any event, he shot Mrs. Minster twice in the head, and then put his gun in her mouth and blew the top of her head. And the Supreme Court in that case said, damage to the body after death is a consideration that can be taken into account as to whether or not it's heinous. In that case, it's later, and it's a very interesting case. Perry was sentenced to death. He cheated the hangman by dying of natural causes in the penitentiary. But so we've got these two conflicting cases. Maybe the dismemberment was an aggravating circumstance, that it was a heinous situation, that it was just absolutely the actual language of D is the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. In the Hunt case, we had a 4-3 opinion. Three judges said, Judge Boswell wrote the opinion, he said, if this does not constitute extreme depravity, I don't know what ever would. But in any case, that's what happened. Well, in the Hunt case, it was or the Harry case, the court knew something about Wesley Harry. They were doing dissents in that particular case, sending down the line. Well, one thing that I thought was an interesting issue was the issue of whether or not there was probable cause to grant the wiretap. What evidence did they have that Harold Nokes had committed it at that time? Why would you grant it when the prosecutor says, and I didn't read you all the stuff because it's too long involved, but he basically, Fred Schroeder, who I was in law school, Fred, he was a nice guy, and he was an honest guy, and he knew that he didn't have a case. He couldn't file a first-degree murder case at this time. But how can he justify probable cause if he can't file a first-degree murder case? Is that an issue? It seems to me it would be an issue. And if it is an issue, then when you find out about the suicide pact, and you find out all these codeine, that's the word I was struggling for, codeine basement. But if you're looking for something and you find that you knew the rings, but that was not conclusive. They knew the statement about the rings and still didn't file a first-degree murder case. But they had the idea that these people were going to commit suicide, and that the key was, because they heard this on the key was Enos Packer. So here's Lanny Rocco, really neat guy, very good sheriff. Everybody out there in that part of the country thinks very highly of him and said he really did a great job. What's he do? He goes in and says to Harold, and Lanny told me that Harold was very distraught all the time he was in jail. He wouldn't eat, his blood pressure spiked. They had the the doctor come in and check his blood pressure every now and then, and it was just skyrocketing off the charts. He knew he tried to commit suicide. He pulled the lens out of his glasses, trying to cut his wrist. Then he goes in and says, Dick Holmes said that Enid Packer, he knew, Lanny knew, but Nokes didn't have any feelings. And he knew Enid didn't have any feelings. And so, about an hour later, Nokes, who was just blowing them out, says, I got to get this off the chest. And told him the whole story. Is that a problem? Can you do something like that and get away with it? Do you have to shoot square with people? Do you have to tell them what really is the situation, or can you make up a little story? Well, it's interesting. The Supreme Court of Nebraska said mere deception will not render a statement involuntary. Interrogating officers, this is a federal case, but it comes out of Nebraska. Interrogating officers allegedly deceptive reference to non-existing autopsy report and his suggestion that the defendant would feel better if he told everything did not overbear defendant's will. That's Norfolk against Houston, a Fed sub case. So, is the court saying it's okay? You can tell them anything you want to. You can make up a story, lead them down the primrose path, and see if they are dumb enough to confess. I thought it was an interesting. I didn't know what the situation was, but I thought it was interesting to find this situation as far as Nebraska. Then I thought the other issue that was really consequential was the issue of the heinous situation that the court allowed these three district judges to come up with this analysis, and it's stuck with it pretty much ever since. As far as a private detective is concerned, Nebraska cases have never really come to grips with precisely what the situation is in that regard. But they have pretty much said private detectives are okay and they can say things, and if they lead you down the primrose path, that's okay. We won't say that that makes a statement involuntary. We've had a lot of thought about Mirandizing, and we've had a lot of opinions that deal with it, but it's very, very difficult. The last thing I want to tell you about, I think it would be interesting. I went out to see Harold once. I tried for years to get to see him. I first glommed onto this case when I was the chairman of the Centennial Committee for the Nebraska Bar in the year 2000. The Nebraska Bar is a voluntary bar, and we're still a voluntary bar, despite what, in my judgment, the Supreme Court did to us. But in any case, the Nebraska Bar turned 100 in the year 2000. And so I was the chairman of the Centennial Committee, and we decided we would write a lot of statements about cases that had been interesting cases in Nebraska, and print them in the Nebraska Lawyer. And I wrote to the clerk of the court in Cook. I knew I was aware of this case, and wanted to get the court file. She wrote back and said, I can't send it to you because Judge Hendricks, who was the judge who tried this case, had sealed the court file. And Judge Battershell, who succeeded him, has said he's not going to release it. So I contacted Judge Battershell, and I said, why can't we have it so we can write this note? He said, there are people here in McCook that don't need to have their names bandied about. What Hendricks had actually done was he knew two of the people who had been trafficking with Kay were significant people in the McCook community. And he sealed the file so that the average run-of-the-mind guy could not run down to the courthouse and find out that so-and-so, who was a pillar of the community and a wonderful guy, has actually been playing house with this young woman who is of fairly nasty repute. Is that a legitimate grounds? Is that a legitimate grounds? All he's doing is protecting the reputation of somebody who's a prominent citizen. Aren't court records supposed to be public? Aren't we supposed to be able to look and learn from these various things? I don't know, but I thought it was an interesting situation. I turned to Paul Douglas, who is a good friend in law school. Well, he was a couple years ahead of me in law school, but we've been friends ever since. And I said, do you have any stuff on this? He said, I've got everything. And he gave me his whole one. And it's really thick. And so, after I looked at it, I thought, I've got to figure out how to get this file and make sure that everything qualitatively will be as straight as snow. And so I wrote Judge Dave Urban, who is the district judge out there now. He's Warren Urban's nephew. And if you ever have the chance to try a case or beat Dave Bounsworth, jump at it, because this is a really neat, thoughtful guy. He's a good judge, and he's very bright. And he said, this file is up in the attic of the courthouse. He said, I'll go up and get it, and I'll look at it, and I'll let you know if I will unseal it. And he did. He went up and got it, and he read it, and he unsealed it. And so I was able to cross reference everything that Douglas had given me with what the court file actually showed. So that was what the situation was. But let me tell you the other thing that was interesting from a lawyer's point of view. Jim Kelly was the second lawyer in this case. Jim is dead now. Whitey Nelson, I don't know if any of you ever knew Whitey. Whitey was at one time an assistant U.S. attorney here. Whitey is dead now. But Whitey was the third lawyer in the case. Jim Kelly said to me, when I was talking to him, he said, you know, Nokes thinks that Dick Holt really shafted him as far as his fee was concerned. He thought that he charged him way too much money for a consultation on a particular matter, when the only consultation was a 2 or 3 minute phone call. And apparently the Nokes family found this out. I talked to Dick about it, and he said no. He said, I charged him a flat fee at the beginning of the case, and I never charged him anything else. So I don't know what Nokes' situation was. But in any event, I wrote Nokes. I'd written him several times. He refused. He wouldn't talk to me on the telephone. He wouldn't do anything. He gave no interview. I wrote him, now this is deception. I wrote him and said, I'm a past president of the Nebraska State Bar Association, and I would be happy to help you in any way if you've got a complaint against your lawyer. If you would like to talk to me about it, I'd be happy to talk to you. The next day, the warden's special assistant called and said, Nokes will talk to you. I got a handwritten pencil note from Nokes telling me what the situation was. He said, I'd be glad to talk to him. I went out and talked to him. I tape recorded it. I've got the tape. Nokes told me a story in 2007 that it was so at odds with the story that he had told Paul Douglas and Fred Schroeder and Lanny Robley in 1974 that it was like two separate deals. There was a big question about whether he took a gun out to the Hoyt's home and brought them back to his house at gunpoint. He said, I didn't take the gun. He said, when I got to my house, Hoyt went downstairs. I was afraid he was going to hit me, so I got the gun out of my bureau drawer and went right down. Well, you know, how many people keep loaded handguns in their bureau drawers? Probably a lot, but anyhow, we checked all the circumstances. It was only from the word go. I don't know what actually happened in this case. I've had a lot of people who've read this book that I consider to be knowledgeable readers, and they had said, we think all three of them were involved. Kay and Enid and Harold, they were all involved in the killing, and they're all guilty as hell. I don't know whether that's true or not, but that's the story. Anyhow, those are the legal issues, and I would be happy to answer any questions that any of you have on any of them. Yes, ma'am.
I apologize if you said this and I missed it, but whatever became of the murder weapon and the axe and the butcher knife? Did they never find those?
The question was, whatever became of the murder weapon and the axe and knife that were involved? The axe was thrown by Nokes into the reservoir at, the knife was thrown into the reservoir at Trenton, Ender's Reservoir. Nokes threw the axe into Frenchman Creek. The police had custody of the gun, but whether or not, see, the problem was they couldn't find it because the bodies were dismembered. They couldn't find any bullets to check as to whether they came from the Nokes gun. The police had Nokes' gun. I don't know if they ever gave it back to Enid or not. That's one thing I didn't check.
And there was no evidence on the axe or the
Well, I'm sure there was DNA evidence probably on the axe and the knife. Unfortunately, one's in the bottom of Frenchman Creek and one's in the
They
bottom
never
of Frenchman Creek.
Let's see, I read the book and I found a very good read in terms of both the menage a trois and the sex and the deception, but also the legal issues. And I had noted many of those that you talked about. One that occurred to me that you didn't mention is what about the ethical issue of representing both the husband and the wife on serious charges?
That's one issue that I really didn't delve into as to whether he hoped to represent them both under those circumstances.
Was he hired? He was a hired attorney.
He was a hired attorney.
That also crossed my mind, and I don't think you would see that at least now.
because looking back, if he hadn't represented both of them, the policeman could have never said, Hope said to give you this message. She would have had an independent attorney, which probably wouldn't have come down there. So I think that's huge.
The comment, and I think that's a very interesting comment, the comment was if they had not had the same attorney, you would have a different person representing Ina, and nobody would have ever said to Harold Nokes, Lanny Robley couldn't have said to Harold Nokes, this is the situation, Ina's got a bad back. And so is that a problem as far as dual representation in this situation?
Because I think that means ineffective assistance of counsel, which is a whole new.
Harold filed an appeal in the Nebraska Supreme Court. He filed post-conviction relief. But to the best of my knowledge, and at least the last time I checked, there had never been a federal habeas action filed in which that issue might conceivably have been raised. Yes, sir.
When you got the court file out of Red Willow County, did you find a copy of the affidavit for the search warrant for that home?
I apologize. These ears are 82 years old.
Oh, I'm sorry. When you got the copy of the court file from Red Willow County, did you find a copy of the search or the affidavit fixed to the search warrant for Harold Hughes?
The question is, when I reviewed the court file in Red Willow County, did I find the affidavit for the search warrant? No, I did not, and the affidavit was issued or was granted by the county court, and I don't know that they ever transferred it upstairs to the district court.
You read us a portion of Judge Hendricks's, apparently the hearing, where he seemed a little troubled by whether there was probable cause for the issuance of an order for electronic surveillance in the home. Did any of the record reveal the factual basis upon which he apparently ultimately entered that order?
Yes, there was testimony by Donald Reed of the State Patrol, testimony by Lanny Robley, and the interesting thing was, and I didn't want to go into all of this. Kay Hine had given Dick Hope a rather extended tape recorded statement, and they did not want Kay Hine to spend much time testifying in the hearing for electronic surveillance. So the judge listened to the tape and then asked Kay Hine, did you tell this? And she said, yeah, everything I said was true. And that was the extent. I think it was a pretty iffy situation as far as electronic. But I think they were convinced that they had the guilty guy, but they couldn't find anything, and they had to figure out how we're going to do it. The cases are pretty interesting on electronic surveillance.
Was Andrew McMullen from Kearney part of the defense team? Andrew McMullen, was he part of the defense team or no? An attorney out of Kearney?
No, Bob Monroe was, but McMullen was. The question was Andrew McMullen from Kearney part of the defense team? It was Bob Monroe. Anything else? My time is up.